Hi, I'm Nick Fishman. I'm the Chief Marketing Officer and Executive Vice President at Employee Screen IQ. And today we're joined by Angela Preston, our Vice President of Compliance and General Counsel. Today we're going to talk about the adverse action process, particularly the two-step adverse action process. Angela, will you tell us a little bit about the adverse action process and why it should be important to employers?
Sure. Adverse action is nothing new. It is a two-step process, as you mentioned, that is required under the Fair Credit Reporting Act. So the first step is called pre-adverse action, and the employer is required to send the applicant a letter with a copy of the background screening report, as well as a notice that's required under the FCRA called a summary of your rights. So that's the first step, and the intent there again is just to put that applicant on notice that there's something in the background check, give them a chance to actually see the report, review the report, and then make a dispute if there's something that they disagree with or that is inaccurate. And then the second step comes into play once the employer has decided not to hire that particular applicant. Once that final decision is made, they're required to send a second notice, which is the adverse action notice, to let them know that there is a final decision. So that's the two-step process.
A lot of employers are asking us on a fairly regular basis, how long are they supposed to wait from the time that they send out the pre-adverse action letter until they then can send out the adverse action?
Well, and I'm going to give you a very lawyer-like answer. It depends. There is no set amount of days under the statute. So it really depends on the relevancy of the job. What the courts and what the FTC have said is that you have to give the applicant adequate notice to take a look at that report, review it, and dispute it if they do find something that they think is inaccurate.
Okay, so I want to hold your feet to the fire. 5 days, 10 days, what do we do?
Well, at least 5 business days, potentially more. It is a consumer protection statute, so the court or the FTC is going to look to make sure that the consumer's rights are protected. And they're not going to be as concerned about your urgency in filling the spot.
Okay, so let's now go back to the two-step process. And the reason we're being so emphatic about that is because, unfortunately, I think we're seeing a little bit of evidence that employers aren't necessarily following that two-step process. Now, they might not be willingly violating the law. In fact, I think they're probably not. But give me some information about why employers aren't getting this right.
Well, I don't know why employers are getting it. It is a little bit confusing just because the statute talks about the 2 steps in different parts of the statute. I think that we're seeing a lot more litigation over this issue, and we recently saw some very big companies get sued in class action lawsuits for not really following the process to the letter.
And these are multi-million-dollar lawsuits. I mean, these are not big. These are not a small deal.
Right. And I think that as applicants are being turned down for jobs, they're asking questions and they want to know why they weren't hired, and looking to the technical requirements of a statute like the FCRA can open up a claim for a class action claim with not only individual damages but punitive damages and statutory damages as well. So the dollars add up very quickly, and I think the plaintiff's bar is really paying attention to this issue. Not that anyone's intentionally violating the law, but I think it's a matter of education and understanding what's required under the law.
Yeah, so I mean, I think, for employers, the key takeaway here is, A, it's a 2-step process. Make sure you do that. In addition to that, make sure that the notices that you're sending out are proper and that they comply with the Fair Credit Reporting Act, and just educate yourself about the process, I think, is the big takeaway. Agreed?
Right, I agree. And keep in mind that a lot of screening companies provide this service on behalf of employers. So if it's something that you're not willing to take on yourself, or you don't have the resources or the knowledgeable staff to do this, it's often something that you can outsource.
So if you're interested in learning more about this topic and many others, please visit us at our website at www.employeescreen.com or follow us on Twitter @EmployeeScreen.